Now, you also, Ray's talking about the paper I wrote some time ago called the Trilogy of Persuasion, which is that you have to have complete coordination between your voir dire examination, the message you deliver on voir dire, your opening statement, and your closing argument. Because these are the 3 times that you get to directly address the jury. Voir dire, closing, and opening. It's the only time you get to talk to the jury directly. So you want to be sure this is when you deliver your message. Now, we used to be able to tell our story on voir dire, and you still can get your message. You still can get your theme out. You can't argue your case on voir dire like we used to, but you can still get your message out, and you can introduce your theme on voir dire examination. And then you come back to opening statement, and in the opening statement, you come to delivery of the theme, and you're raising it here in voir dire. Now, in opening statements, you're putting a little more flesh on it, and you're starting to flesh it out. And then you also tell them in opening statement, here's what I'm going to bring you. I'm going to bring you evidence that will support this, and you will see in the evidence that so-and-so. Now, then you go into the evidence and you flesh it all out. Then you go into the summation, and it's the same story you told over here. That gets you a lot of credibility. When you're telling the same story, and this is where you do want to make the same argument, because you want to be able to come back and say, as I told you on voir dire examination, or as I told you in opening statement, the more often you can remind them that this is what I told you. I did what I said I was going to do. But then that's how you do repetition, okay? That's what refreshing the memory of your audience frequently means. Now, of course, the other thing in there, the things that have to have complete coherence, your pleadings, okay? Your voir dire examination, your opening statement, your body of evidence, your closing argument, and your final judgment. I mean, those are the things that should all come out. If you do it right and you get all the breaks, those things should all be just alike. That you plead it over here, you tell about it here, you introduce it to them here, you prove it to them here, you remind them about it here, and you persuade them on it, and then you get a judgment that looks just like that. It's just that simple. But that were true. There are lots of traps along the way, but that's the ideal. So with that in mind, when I'm preparing a case, before I ever do investigation, before I ever get into depositions, certainly before I do depositions, I draft my pleadings first. I may not file them until next year, but I draft my pleadings first. I draft what I want to be the court's charge. That's where you start, because everything you're doing, what is the target demographic? The target demographic of your message is jury room deliberation in the aspect of each element of the court's charge. So if that's where your case is going to end up, it's going to end up in the court's charge, in the discussion of your court's charge, then you should start at the same place. So we would always, and it was very simple, when the greatest gift the state bar ever gave us was the pattern jury charges. When I started practicing here, there were no pattern jury charges. You had to go research what's the proper way to ask this question, and the opportunity for error was huge. But you start with your court's charge. What is the jury going to be asked to answer? What are these specific questions? And then you start with that, and then you figure, okay, how can I get them to answer those questions in the way what I need their answers to be, and how can I arrive at that? And then you develop from there. The next thing Mr. Aristotle said was, execute the required level of emotion. This is where we fail miserably. Now, emotion is for your closing argument. Emotion is not for your opening statement. It's out of place. It will play into the stereotype of lawyers that you don't want to be tagged with. Emotion, properly done, is probably best reserved for the closing. If you're the plaintiff, it's best reserved for the closing portion of the closing argument. Because at that time, you want the emotion to be, okay, there you're through, now go in the jury room and do what I just told you. But you don't want the defense lawyer to have any opportunity to rebut it. And at that point, he can't do so. So limited emotion, but there is a place for emotion. You need emotion because one of the things that we fail to do, we don't engage jurors. You probably won't have any trouble with this question. What is the one single word most frequently used by jurors to describe jury service? What? Boring. Exactly. Boring. In fact, I don't even know what the second choice was. Yeah, I mean, it is boring. You know why? One of our greatest opponents in the courtroom in every trial is David Kelly. Because David Kelly wrote Ally McBeal, he wrote Boston Legal, he wrote all these delightful sitcoms about lawyers that made law and trial look like so much fun. They'd stand up and make these 180-second closing arguments, and the jury would just free criminals and bring in multi-million-dollar verdicts. And so it made law look like fun. Then they get over to the courthouse, and the first thing they meet is the jury shepherd. And the jury shepherd they call them that for a reason, because they treat the prospective jurors like sheep. They can't say anything, they can't do anything. They sit here, don't read, do that. And then you get into the courtroom. You finally get into a courtroom. The first time I had the privilege of being called for jury service. And I went over there and I saw what jurors go through before they come to me on voir dire examination. I went back and completely rearranged. I rewrote my approach to voir dire examination because I saw that what they were in the state when they're sitting here in a panel like you are, what they are is starved for information. They don't know, nobody tells them anything. They don't know if they've come there to try to put a guy in jail who chopped up his neighbor's body and threw him in the Gulf. Or they don't know if they're there to take a child away from a mother. They don't know if they're there to award one of those multi-million-dollar verdicts. They don't know if they're going to have a neighbor on a DWI. They have no idea. So this provides a wonderful opportunity for the lawyers. Some judges try to take this away. They should just sit there and keep their mouth shut. Their job is to judge, not to tell stories. That's my jury, not theirs. That's their jury. It's their jury for the law. It's my job to educate them. It's the defense lawyer's job to educate them in the fashion within the rules. And too many judges. Now, federal judges can do it. They have the right to do it. They can do anything they want to. If they want to, they can stop and cross-examine your witness in the middle of you can be putting on a case, and a federal judge, you can say, "Oh, witness be excused." I say, "No, I got a couple of questions." Next thing you know, the judge asks a couple of 3 questions and just completely blows what you were planning on bringing on with your next witness. But at any rate, most judges will not give them a big prep of what your case is about. So when you stand up in front of a jury on voir dire examination, you have a splendid, splendid, splendid opportunity. And that is, you have the opportunity to be the first person to tell them why they're here, and to tell them what their role is, and to tell them why they are relevant, and to tell them why they've been sitting down there for 3 or 4 hours waiting to get here. And so we all love our educators. We really love to be educated. And so you want to start out not being an advocate. You don't want to be up there arguing your case on voir dire examination. On voir dire examination, you want to be doing 2 things, not in this order. You want to be educating the jury so as to, you start out with them liking you. You give them valuable information, valuable to them, not valuable for you that they hear it, but valuable to them. And there's a very simple rule of voir dire examination. The lawyer should do about maybe 15% of the talking, and the jurors should do maybe more like 85% of the talking. You should be asking questions. Now you can formulate, you can put your message, you can deliver your message in the question. You can deliver the message in the how do you feel about, and that kind of question. So you get your questions out, but you don't stand there and give a long spiel and do an argument and be persuasive and then say, okay, now, how do you feel about that? I just told you how I feel about it. How do you feel about it? You don't find out anything. You find out nothing like that. I'll tell you one more thing. I'm not going to spend much time on voir dire, but let me tell you this about voir dire. The most valuable thing you can possibly have on voir dire is to convince the court to let you do a supplemental juror questionnaire. We've been selling that to Texas judges for years. If you can get the court to let you give a jury a supplemental juror questionnaire, you will get such valuable information you cannot believe it. And the way you do that is you confine it. We talk about this. We've been talking about this at State Bar in State Bar speeches probably since, I guess we started doing supplemental questionnaires maybe in the early 90s when the first came up with them. And the way you get them is you convince the court that it will shorten the trial. And that's the key to everything. Whatever you want, it doesn't matter. If you can convince the court it'll shorten the trial, you'll get it. So you have to convince the court because the court, these people they've filled out a form already. And a supplemental juror questionnaire, you may have 60 panel members or 45 panel members or whatever. Then you got to stop. You got to pass out questionnaires to everybody with a pencil, and they sit there and they got to all answer these questions. Then they got to gather them up, and then they got to make copies of them so that the court has a copy and each lawyer has a copy. There may be five sets of lawyers, you don't know. So each lawyer has a copy. Well, that's a lot of work. And so the judge would say, no, I'm not going to do that. Say, no, Judge, we're going to do it. We've got the questionnaires here. We've got them on a hardback. We've got all the pencils. We got 3 paralegals right here who are going to gather these up. They're going to take them downstairs. We've got somebody standing by a Xerox machine. We're doing all that. All you need to do is give them a break while we do it. So then, the reason supplemental juror questionnaires, and this is the greatest advance in voir dire examination since it started. The reason is because, obviously, it's not rocket science. People will write down things in private that they would never, ever say in front of 40 or 50 strangers. Again, look at things from the viewpoint of the juror, the panel member. They come into a courtroom after they've sat for 3 or 4 hours and not be able to do anything. They're told to get in line. They have to follow. You have to always have to be behind this person, in front of this person. You got to. Everything is controlled. And now, a lawyer stands up and asks a question about your personal life. Like the lawyer. This is true story, as opposed to everything else I'm telling you now. But this lawyer actually stood up and said, "Ma'am, this is going to be it's going to be a long trial. And so I'm just wondering, are you going to be able to make it? This trial could run 2 months. Are you going to be able to make it?" And she said, "Yeah." I said, "Sure, of course I am." He said, "Well, I was just wondering because how far along are you?" And she said, what?
"I'm not pregnant."
True, that actually happened. She said, "I'm not pregnant, and I'm also not voting for you." But see, it's not her. You just offended every member of the jury panel by digging into their personal lives. So, and remember, there are 2 units up there. There's you, well, they're the lawyers, and there's them. And they coalesce. They identify with each other. And so when you pick on one juror, I've heard lawyers say this, "I took this guy apart because I knew I was going to strike him. So I just took him apart." That's stupid. Because when you're offending a juror, you're offending all the jurors. You really are.